Present topic for discussion is Civil Procedure Code 1908 and Limitation Act 1963. Legal Disability Sections 6 to 9 and Acknowledgement Sections 18 to 20 of the Limitation Act 1963. Dear student friends, you are aware that I am Dr. Rega Surya Rao, Principal, Retired, Barrister Raja Bhosle's Priyadarshini Gyan Prabodhini's Law College, Fulton, Satara District, Maharashtra, India. I have been delivering lectures online for the benefit of our law students. So far, I have delivered 132 lectures out of 16 subjects. This is my 133rd lectures and 8th lecture from Limitation Act. 8th lecture from Limitation Act. From CPC and Limitation Act, I have delivered so far 7 lectures. First 5 lectures on Civil Procedure Code and 6th and 7th lectures I delivered on Limitation Act. In the last clue classes, that is in 6th lecture, I explained in detail about Limitation Act scheme and contents of the Limitation Act, wherein the body of the Act comprising of 32 sections and schedule containing 138 articles. In 7th lecture, that is in last lecture, I explained in detail about Limitation Act, its object, purpose, and section 3, 4, 5 and section 12 to 15 of the Limitation Act, which deal with section 3 deals with bar of limitation, section 4 court holiday, section 5 condonation of delay, these 3 sections, and computation or calculation of period of limitation under section 12 to 15. These 3 aspects I explained in the last class. Today in this class I wish to take up legal disability and acknowledgement. Legal disability and acknowledgement. Dear friends, section 6 to 9 of the Limitation Act 1963 lay down the provisions relating to period of limitation for filing suits in respect of legally disabled persons. As I told you several times, according to section 11 and 12 of Indian Contract Act, a person who wants to enter into a contract or who wants to file a suit must be competent to do so within the meaning of section 11 and 12 of the Indian Contract Act. So according to section 11, a person to sue or to enter into contract, he must be a major, means he must not be a minor. Secondly, he must not be of sound mind and he must not have been disqualified by law in force to contract. But the persons disqualified by law in force, insolvent and others will come within the meaning of other aspect. The Limitation Act speaks about suits, appeals and applications in respect of civil matters to be filed in courts of law, civil courts of law, except very few exceptional cases. And that is why only this legal disability refers to filing of suits in respect of legally disabled persons, namely minor, insane and idiot. Minor, insane and idiot. Minor, a person below the age of 18 years is minor, and the person who, if a guardian is appointed, his minority extends to 21 years. All these rules and regulations I explained in detail in section 11 and 12 of the Indian Contract Act. Secondly, minor. Second one, a unsound person. A unsound person means a person who is suffering from mental disease and he is not able to distinguish between right and wrong. That is also legally disabled person. Thirdly, idiot. Idiot means a person, he is like a fool. He doesn't know. He has very low level of mental caliber. These people do not know what is right, what is wrong. They won't be able to distinguish between right and wrong. To get sense, soundness of mind, the minor requires particular age. If he is 10 years old, he requires 8 more years. If he is 5 years old, he requires 13 more years. If he is 2 years old, he requires 16 more years. If guardian is appointed, 3 more years his minority is extended. Even a child in womb is considered as a child in existence. A child in womb, in case of legally disabled persons, legally disabled person will get the right to sue will be accrued on attaining the age of majority. In respect of legally disabled person is a person who is not qualified in the eyes of law to file a case. Legally disabled person means a person who is incompetent in the eyes of laws to bring an action against another. He is not competent. He is mental incompleteness. So the legally disabled person, if he is a minor or unsound man or idiot, till that idiocy is cleared, till that unsoundness is cleared, till this minority is cleared, he will not get right. That is, right will not be accrued until and unless this disability is cleared. After cessation of this legal disability, the limitation period will start. Suppose a minor is there, he has to file a case against another. If through next friend, immediately it can be done. But the minor himself will have to file a case, boy or girl, some age of minority will be completed. So if the minor of boy or girl, after completing the age of 18 years, he or she will become major, then he will get entitled to file a case against the other. So that means the right to sue will be accrued on attaining the majority. Here, for filing a case, the period of limitation is, for example, 3 years. So if the minor is 10 years old, 8 years plus 3 years. After 11 years, he will get right to sue. If the minor is 3 years old, he will have extension of time 15 years plus 3 years, 18 years. After 18 years, the right to sue will be accrued. Suppose the child is in mother womb, or a child in mother womb also deemed to be a child in existence. If the child is born alive, if he is born alive and he survives for not less than 48 years, the child is a child. That child is declared as a child in existence, and that child will get right to sue after attaining the majority. Suppose it will take some 3 more months is required for delivery, and then the child will come into existence after 3 months. That is 3 months plus 18 years. 18 years, 3 months plus 3 years. Like that, the period of limitation will be computed. As I told you in the first class, that is in the 6th class, Limitation Act, here the section first division contains 113 articles divided into 10 parts. Part 1 to 9 deal with limitation period 3 years or less than 3 years period in respect of various suits. Suits in respect of account, suits in respect of contract, suits in respect of movable property, suits in respect of immovable property, suits in respect of trust and trust property, suits in respect of tort and miscellaneous issues. But part 10, which contains only one section, 113, speaks about the suits in respect of which there is no any limitation period. So far as the people that come within the meaning of legally disabled, there is no any specific period of limitation. There will be part 1 to 9, specific period of limitation is there: 1 year, 3 years, 6 years, 50, 12 years, 15 years, 30 years, like that. The limitation period is specifically mentioned. So far as the minor is concerned, there is no the period of limitation cannot be fixed certainly, because it depends upon the present age of the minor. Similarly, unsoundness of mind. If the person is of unsound mind, he is undergoing treatment in some mental hospital or taking some medical treatment, so how long within what time he will get sanity, within what time he will come to a normal position, when he will be his mental disease gets cured, we won't be able to tell. Similarly, idiot means we are observing in the society, some parents will have a child. That child is idiot, he doesn't know anything. Though he completes the age of 20 years also, he is not able to speak properly, he is not able to identify. So that type of people are called idiots. So minors, insanes and idiots are not qualified legally to file a case against other person. So this section 6, 7, 8 and 9 relate to filing of suits. A legally disabled person can file a suit after getting cured from legal disability. Then he can file a case. So this is what is called cessation of legal disability. A 10-year-old boy will have cessation of legal disability after 8 years. If he wants to file a case for movable property or breach of declaration or contract relating to accounts, he can file a case within 3 years. And if he is 10 years old, 8 years plus 10 years, subject to the exclusion of limitation period as prescribed under section 12 to 15 of the Limitation Act. Similarly, the section 6 clause 1 speaks about legal disability. The legally disabled person will get entitled to sue after the cessation of legal disability, when the legal disability is cleared. When minority is cleared, when unsoundness is cleared, when idiot is made normal by medical treatment or other. So that is what is called, when the legal disability is cleared, he will get right. From that time only, limitation period will be calculated or computed, whether it may be 6 months, 1 year, 3 years, 3 years, 12 years, whatever it may be. So that is section 6 clause 1 speaks about the legally disabled person can sue after cessation of the legal disability. Section 6 clause 2 speaks about double legal disability. Double legal disability. Suppose X has to file a case against Y, but X is minor. X is some 12 years old. But for cessation of legal disability, he has to wait for 6 years. To get minority, for completion of minority and entry into age of majority, he should wait for 6 years. After attaining 6 years of age, immediately either on attaining majority or just before attaining majority, a few months or few years before the majority, one more disability, he becomes insane or becomes idiot. So another disability continues. So though he has completed the age of 18 years, he became, there are some children from by birth they are very good. After some time, up to 5 years, 6 years, they are okay. After 7 years, 8 years, so they become mentally or physically disabled. I have seen so many some cases. The boy is healthy, the boy is all right for up to 8 years to 10 years. Thereafter, he became insane, physically and mentally disabled. That type of these issues are there. Similarly, the boy or girl is mentally okay, but by virtue of minority, minority, he or she is 16 years old. Till 16 years old, the boy or girl is okay, sound, but the disqualification is minority. But within 2 years, the minority will be cleared. By before attaining majority, age of majority, that is 18 years, that is in 17th years, or before entering 18 years, the boy or girl got insanity, became unsound person, physically or mentally disabled. So then, even after, even though he is completes, though he or she completes age of minority, they cannot, the right to show will not be accrued. Then second. So when one disability follows another disability, until and unless all the disabilities are cleared, that is the cessation of all the disabilities, the minority, after cessation of minority, another unsoundness has come. After unsoundness, idiocy, like this. And so until and unless all the disabilities are cleared, the limitation period will start. From that, the limitation period is 3 years, 6 years, 12 years, whatever it may be, it will be followed. So section 6 clause 1 speaks about symbol one disability. Section 6 clause 2 speaks about double disability, one disability after another disability. Next, section 6 clause 3 speaks about legal disability till death. Legal disability till death. Legal, suppose till death. So the boy or girl completed minority, afterward enter into the age of majority, and then entered into, became unsound, but the unsoundness of mind has not yet been cleared, or basically the boy or girl is physically or mentally disabled. There is no question of age limit. For physically or mentally disabled person, there is no question of age limit. Until and unless the boy or girl comes to normal, when they will be able to distinguish between right and wrong, then only we say that the boy or girl is has come to the cessation of legal disability in respect of that boy or girl is extinguished, and then only the period of limitation will start. Sometimes what happens is the boy or girl is legally disabled by virtue of unsoundness of mind or idiocy. The idiocy or unsoundness has not been cleared till death. When it is not been cleared till death, then we shall think about legal heir or legal representative. If the legal representative is major, the legal limitation period starts. Suppose the mentally, physically or mentally disabled person is 10-year-old. At 10-year-old he dies, and whoever is the legal heir, then the limit, if the legal heir is major, legally qualified within the meaning of section 11 and 12 of the Indian Contract Act, immediately limitation period will start. Suppose the after death, that legal heir is 8-year-old or 10-year-old, until unless the legal heir should get majority, then only when the legal heir, the cessation of legal disability must take place in case of the legal representative or legal heir. Then the period of limitation will be started. This is with reference to section 6 clause 3. Clause 3. For example, so even though the legal disability is cleared, whether as in by virtue of section 6 clause 1 or section 6 clause 2, even after the cessation of legal disability, when the legal disability is cleared, cessation of legal disability is accomplished, and then limitation period start. After cessation of legal disability, the minor or unsound person will have to file a case, but the period of limitation is 3 years. He or she did not file a case, kept quiet for 1 year, and then died. And then when after 1 year, even though he got a right to sue, he is accrued, but after cessation of legal disability, limitation period start. The person to sue keeps quiet for 1 year. The period of limitation is 3 years. He died after 1 year without filing a case. Now the period of limitation for that particular case is 3 years. So he did not file a case for 1 year, and limitation will the remaining 2 years limitation period will be there. If the legal representative is major, within that through 2 years he will have to file a case. We will have to file a case within the period of 2 years. This is when once the limitation period is started, it will not be stopped. This is with reference to section 6 clause 1 clause 2. Section 6 clause 1 means cessation of legal disability. Section 6 clause 2 speaks about double one legal disability of another disability. After cessation of all legal disabilities only, limitation period will start. And third one is disability till death. And disability even after cessation of legal disability, if the plaintiff, if the major keeps quiet for 1 year and remaining period is only 2 years, within 2 years only, if he dies after 1 year, within 2 years, the legal representative, if he is a major, will have to file a case. Suppose that legal will have to file a case. This is with reference to this within 2 years. Then next one is finally section 6 applies to child in mother's womb also, because a child in mother's womb is declared as a child in existence. If a child in mother's womb, he will come to the child is expected to born after 3 months. That 3 months period after delivery, after birth of the child, 18 years period will be there. That 3 months plus 18 years plus 3 years, like that it is to be completed. All the rules are applicable for this. Next, section 7 speaks about joint action. So sometimes only one person files a case, sometimes 2 or more persons will file a case. Suppose the person to show the plaintiff is, sometimes the plaintiff may be only one person, sometimes the plaintiffs may be 2 or more persons. When there are 2 or more persons, if they want to file a suit, if there may be 2 plaintiff, 2 persons or 4 persons or 5 persons. One is major, one is 10 years old, one is 18 years old, one is 30 years old, one is like this. So there where the plaintiffs, the 2 or more persons, joint plaintiffs, if out of 2 or more, one is major enough. Out of when the group of persons wish to sue, out of them there may be 2 or 3 or 4 or 5. Out of all of them, if one is legally qualified, major and sound mind, the limitation period immediately starts. Suppose all are minors. One is minor, one is unsound, one is idiot, and all. Suppose there are 2 or more persons, if legal disability is cleared, that is cessation of legal disability of even one person, then legal disability will start. One is idiot, one is insane, one is 15 years old. Then third person 15 years old. After 3 years, the cessation of that is when he attains majority after completing 18 years. then limitation period will start. So the others, one is idiot, one is unsound mind, another one is 10 years old, will not be taken into consideration. When two or more persons wish to file a suit, if one is legally qualified, it is enough. If the legal disability, if the cessation of, if one is legally qualified, he can file a case. There is no need. There is no need to. It is not necessary that all the persons who wish to sue should be legally qualified persons. So one is legally. So all are legally disabled. If legal disability is cleared by one in respect of one person, that is cessation of legal disability in case of one person is enough to file a case, and then from that time limitation period will be started. This is with reference to section 7. Section 8 is an exceptional clause. So this is an exception to the exceptional clause. The rule of the above privileges of legal disability under 6 and 7 are not applicable in respect of suits to enforce right in respect of preemption. Preemption means first priority. Right of preemption means first priority. Suppose you are already a shareholder of a company. When suppose a company is there, it issues shares. First time the company issues shares, already there are shareholders are there. When the authorized capital is 100 crores, in first instance the company issued 50 crore shares. After some time of running the business, the company wanted to issue 25 crore shares. When the company issues shares, the first opportunity should be given to the existing shareholders. The existing shareholders' right is called right of preemption. That is right of preemption. So the rules under section 6 and 7 are not applicable in respect of enforcement of right of preemption. That is another case. Suppose in one more example I want to tell you, there is a property, joint family, there is a property of two or more persons are owners of some immovable property. Two or more persons. The property is some 1.5 crores. Three of them are owners. Each is entitled to get 50 crore. Suppose out of three, one wants to sell the property. So there may be an agreement, condition precedent or agreement to that effect. If anybody wants to sell his share, he should sell his share first to other two co-owners. If they don't want, then he can go for this thing. So the other two persons will have the right. That right is called right of preemption. So far as this enforcement of rights, right of preemption, so the rules under section 6 and 7 are not applicable. That is why they are not applicable. This is then section 8 is exceptional clause. These are the various rules relating to section 9. Lastly, section 9 speaks about running of continuation or running of the limitation period. So when once limitation period starts, it does not, once limitation period starts, it will not be stopped. So before commencement of limitation period only, all exclusions, exemptions, condonations and all will be there. When once limitation period is started, it will not stop except by some statutory provision, and by legislation or other special arrangements to that effect. So this is with reference to legal disability. Section 6 to 9 of Limitation Act lay down the provisions relating to filing of suits by legally disabled person. That is minor, unsound and idiot. But legally disabled person, according to section 11 and 12 of alien enemy, insolvent and other things are there, but they are not covered under the Limitation Act. They are covered under the respective legislations. So Limitation Act relates to civil suits only in few cases, that is Article 114 and 115 relate to criminal matters under second division, the second division part 1, two articles relating to criminal matters, and almost all the sections and articles relate to civil matters only. But some there are special courts. Limitation periods are governed by respective special acts. Tribunals, the limitation periods and all are regulated by the Indian Tribunals Act 1985. So like this, so many the special courts which are established under special enactment, those rules will be applicable to them. So with this, section 6 to 9 speaks about legal disability. Section 6 clause 1, the right accrues on cessation of legal disability for one person. 6.2 speaks about double disability. One disability for 8 years and another disability continues for 3 years. 8 plus 3, 11 years, and 3 years limitation period, for example. 8, 3, 11 plus 3, 14 years will be allowed to file a suit. Then that is. Third, the disability continues after death. So long as the person to sue is alive, legal disability by virtue of is a minority or unsoundness is not cleared, but he died, then the legal representative or legal heir will get entitled to sue. If the legal representative is major, he can sue. Limitation period starts immediately. He can sue. But if he suppose he is minor, is unsound, the same rules will again follow. That is this thing. Section 6 clause 3 speaks about joint action. Section 6 clause 3 speaks about disability till death. 6 clause 1, cessation of legal disability by one person. 6 clause 2 deals with cessation of two disabilities. 6.3, disability till death, then legal representative will come. And section 7 speaks about two or more persons. If legal disability is clear, one is a legally sound person competent, the limitation period will be started. Section 8 is the exceptional clause. Section 9 is running clause. These are the rules with reference to legal disability. Next one is acknowledgement. Acknowledgement gives fresh start of limitation period. Acknowledgement is a process by which limitation period starts fresh. Section 18 to 20 of the Limitation Act 1963 lay down provisions relating to acknowledgement by written instrument or part to payment. Section 18 deals with acknowledgement by written instrument. Section 19 deals with acknowledgement by part payment. Section 20 deals with acknowledgement part payment made by some third person. So what do you mean by acknowledgement? To acknowledge means to accept or to admit. Acknowledge, to accept or admit some, to admit. Acknowledgement means to acceptance of receipt or admitting a liability. In civil litigation, admission is an acknowledgement, and in criminal law, confession is an acknowledgement. To acknowledge means to admit, to accept some liability or receipt of some payment. So this acknowledgement, section 18, 19 and 20 of the Limitation Act lay down the provisions relating to acknowledgement. Now, dear friends, we think that when you take loan from bank for housing loan or any other loan, personal loan, the repayment for car loan or anything, the repayment period may be 10 years or even 20 years. One wise candidate think that okay, we gave promissory note. The life of promissory note is only 3 years. We have taken installment for 20 years. After 3 years, we can pay installment for 3 years. After that, we can avoid payment. One may think intelligently. No, when every installment, from every installment is part payment, from that part payment, fresh period of limitation will be started. So suppose I have taken a loan of 1 lakh from one friend or anybody. I executed a promissory note, and I should pay him within as early as possible on his demand. If I don't pay within 3 years, my creditor, my friend who gave me 1 lakh loan, should file a case against me within the period of limitation, within 3 years only. If it does not go to court within 3 years, it will become time bound debt. If he files a case after 3 years, his suit will be dismissed. So this acknowledgement. Suppose I took loan from my friend 1 lakh before due date. After 2 years, I may request my friend. I want to give. So, dear friend, thank you very much for having provided me the advance of 1 lakh. Due to some financial problems, I am not able to repay it. Yeah, I want to. You please cancel old promissory note, and I will write a new promissory note, like that. And or my friend should pay me 1 lakh. So you let us cancel our promissory note. My friend will write a fresh promissory note. That may be there. Or no, I don't have money. I will give some movable property, some gold. That is what is called pledge. That is another contract under Sale of Goods Act. No other. You keep my house as a mortgage. That is. So these are different types of amendment. And the section 62 of Indian Contract Act speaks about novation. So novation is a contract wherein new contract is created in the place of old contract. The new contract becomes a consideration for the old contract. So this type, if you want to know the detail, you refer to my contracts 1 lectures, the doctrine of novation. So like this. So by entering into fresh contract by means of novation, another promissory note or another mortgage deed or pledge agreement or whatever it may be, yes. Or without any contract, he may write a letter. Dear friend, I find it due to some financial problems, I am not able to give your money. I will give your money next year. Don't worry about the period of limitation. So that letter date, from the date of that letter, it is a written instrument. 3 years of 3 years limitation period will be there. Suppose I give some written instrument, it should be attested by some witness. Suppose sometimes a letter say that without negative reply, as if I have not taken, that reply in negative also will be treated as acknowledgement, provided the plaintiff can establish proper witness. So even without written, a contract may be oral or writing, express or implied. Suppose even if I don't write, if I say in the presence of some two elderly persons, I have taken you loan of 1 lakh 2 years back, but due to some personal problems I am not able to clear the loan, but I will give you next year, like that I say. Two witnesses will be there. That that statement on the onward, 3 years limitation period will be counted. So for that, when it is oral, the plaintiff will have to produce witnesses supporting his claim. This is the problem. So the Limitation Act does not prohibits does not entertain action suit after limitation period, but by limitation period of 3 years, the right of the creditor is not extinguished. Limitation Act would never destroy the right of the legitimate right of the creditor. So even after limitation period, if the debtor makes payment to creditor, the limitation law will not will not prevent, will not object. So this is with reference to acknowledgement in writing. Section 18 of the Limitation Act speaks about acknowledgement by written instrument. Now second one is Section 19 speaks about acknowledgement by part payment. Part payment means any amount which is not equal to principal and interest. So only interest or part of the interest also constitutes part payment. In part payment, when we take any loan from bank, first of all, some banks, whatever amount is paid, the all the amount will be received as a part of interest only. Interest only. So the major part of the amount is accepted as interest, and minor part of the amount is accepted as principal in the beginning. So part payment includes the payment partly principal, partly it may be partly principal, partly interest. It may be a part of the principal, the amount is paid, or it may be part of the interest, it may be paid. Full interest is paid. Whether the debt means not only principal but also interest. Interest and principal put together is debt. So whatever amount which is less than full value of the debt is called part payment. When we take loan, car loan or building housing loan from bank or any other source, every payment, every installment amounts to part payment. From the part payment, 3 years of 3 years limitation period will be there. So this is what is called the second category of acknowledgement. So section 20 of Limitation Pay Act, section 20 of the Limitation Act deals with part payment made by third person. Part payment made by third person. So when a part payment is to be made by third person, that third person must be an authorized person. He must have made that part payment with the consent of the debtor. With the consent of the debtor. Either the debtor can pay part payment, or his authorized agent can make part payment, or his near or dear friend or relative can make part payment in consultation with the consent of the principal debtor. For example, in insolvency, when insolvency petition is filed, the purpose of insolvency petition is to get cleared from the liability. Assets are 10 crores, liabilities are 20 crores. That trader files a insolvency petition to avoid 20 crore liability and surrender 10 crore liability. He gets relieved. That is there. And similarly, there may be I gave loan of 1 crore to one partnership firm. That partnership is about to be dissolved. This 1 crore is about to be time barred. Suppose after 10 days, my debt, my amount paid to advance to firm will become time barred debt next month first. But one of the partners is my friend. In order to benefit, to give life to my debt, one of the partners, my friend, made part payment of very small amount, 1,000 rupees or 10,000 rupees. But that payment is not valid. Though he is a partner, if he makes payment, he must do it in consultation with all the other partners, or according to the partnership deed, he must be authorized to do so. But without the consent of partner, in order to help his friend, that is myself, if he makes part payment, it is not valid. So section 18 speaks about acknowledgement by written instrument. It also includes if the debtor say that I need not pay you any amount, you say that I should pay you money, but I did not take any amount, like that also. If the creditor will establish evidence as to the payment made, then even that letter in negative also constitute acknowledgement. From that letter in negative with supporting witnesses will become written acknowledgement. From the date of letter, 3 years limitation will be started. So section 18 deals with acknowledgement in writing. Section 19 deals with acknowledgement by part payment. The part payment may be a part of interest or full interest, part of principal, whatever it may be, making payment of full principal, leaving interest, whatever, but this particular payment should not clear the debt 100%. That payment, any payment less than the principal and interest total, that payment is, if the liability is 1 crore, interest is 25 lakh, 1 lakh 25 crores, 1 crore 25 lakhs. If 1 lakh also, 10,000 also is a part payment, 1 crore 20 lakhs also will become part payment. So the total amount is 1 lakh, 1 crore 25 lakhs. So there is no more or less, but the debt may be any part. It may be a small part or a major part. So it amounts to part. So section 20 speaks about acknowledgement by third person. So when payment is made by some third person, it should be done with in consultation with the other debtors only. Other debtors only. Then only it should be in consultation with other debtors only. Acknowledgement should be made. These are the this is the position with reference to this. So there are some conditions. An acknowledgement by written instrument or part payment or other person to be made, it should be made before the elapsed expiry of the period of limitation. And secondly, it should be if it is done by third person, it should be in consultation with the other partners or co-proprietors. This is with reference to section 20 clause 1, section 20 clause 2, section 20 clause 3. 20. See, acknowledgement by a debtor or his authorized agent, acknowledged by one among the partner. Section 20 clause 2, acknowledgement by one of the partners if they are authorized to do so. Section 20 clause 3 speaks about acknowledgement by owner of limited owner of joint property. For example, acknowledgement made by manager or karta of joint family property in consultation with other members, that is co-partner, that payment is valid. Section 20 clause 3, it refers to Hindu joint family. So these are the various issues relating to acknowledgement. Dear friend, so far in Limitation Act, this is my third lecture. In sixth lecture, I explained in detail about body of the Limitation Act and schedule, entire scheme and contents I explained. In seventh lecture, that is last lecture, I explained in detail about Limitation Act, underlying principles, section 3, section 4, section 5, section 3 bar of limitation, section 4 court holiday, section 5 condonation of delay. These three I told. A period of computation of limitation period, that is section 12 to 15 I completed in last class, that is the 7th class. This is 8th class, 8th lecture on CPC and limitation. In this 8th lecture on CPC limitation and the 3rd lecture, I covered legal disability, section 6 to 9, and acknowledgement by written instrument and part payment, section 18 to 20. This topic I have covered. See, in addition to that, there are some small topics. Section 17, where a suit or application is filed by on fraud, mistake, concealment of fraud, the period of limitation would not start until and unless the fraud is detected by applicant. Suppose there are some cases the suit is filed, the suit or application. This section 17 relates to suits and applications only. It does not relate to appeal. Suppose this acknowledgement and legal disability, they refer to suits only. They do not refer to appeals or applications. So here this section 17 refer to section 16 speaks about death before the accrual of right. Suppose there is a minor or unsold person. So before accrual of right, so the insanity will be cleared within 2 months, or the minority will be cleared in 1 or 2 years. Before cessation of legal disability, that person dies. The rules of limitation after the cessation of legal disability, when once the person before accrual of the before getting the right to sue, that person dies. He may be a minor or insane person. The legal representative will come to the picture. If the legal representative is major, immediately limitation period starts. That is what section 16 tells. Section 17 speaks about where suit or application is filed based on fraud, mistake, concealment of fraud. So there are some cases, there are some contracts wherein fraud, misrepresentation, uninfluence and other flaw in consent is placed by one party. Then when the fraud or concealment of fraud, mistake is detected, from that time only the limitation period will be started. Like this, similarly, section 21 speaks about substitution of plaintiff or defendant. When a plaintiff is substituted in one place of one plaintiff, another plaintiff is added, and in addition to existing plaintiff, one more plaintiff is added. Similarly, in defendant is changed, or in place of one defendant, one more defendant is added. Whatever it may be, since adding or addition, the fresh period of limitation will be started. Fresh period. Suppose the substitution of prince, adding of prince plaintiff, or substitution of plaintiff, adding of defendant, substitution of defendant is done by mistake, the earlier date will follow. The earlier date will follow. Suppose the suit is filed on 1st November 2020. On 15th November, plaintiff, one more plaintiff is added, or another plaintiff is substituted, or similarly defendant is added or defendant is substituted on 15th. So here the period of limitation starts from 15th November. If a plaintiff added or a defendant added, plaintiff substituted or defendant substituted, from the date fresh from the date of substitution, that is 15th November, limitation period starts. Suppose the substitution or adding of a principal or defendant is made by mistake or fraud or concealment or anything, so the earlier date will follow. Earlier, that is 1st November, the period of limitation will start. So these are the various things. Continuing thing, for every, when an act is continuous, from every continuous act, fresh period of limitation will be started under section 22. These are the various. Next, section 23 speaks about suits for compensation. The limitation period starts when injury. Suppose a tort is committed and some other person got injured. The injury may be economic injury or personal injury or mental injury, whatever. When once the injury it takes place, from the date cause of action takes place, limitation period starts. So these are the various provisions relating to Limitation Act, dear friends. So in Limitation Act I have covered very important topics so far. So these topics will be enough from examination point of view, and other sections, if any, you can simply refer Bear Act and continue. Thank you very much for your patient hearing. Some students are requesting me to take some classes on CPC also. Actually, I wanted to take up jurisprudence. I wanted to open most important subjects and deliver 2 to 3 lectures on each subject, covering all the subjects first. And due to demand of some students, I am requested to take a few more classes on CPC. So I will take 1 or 2 classes on CPC and then proceed to jurisprudence. I will deliver 2 or 3 lectures, and in labor law some difficult topics are there. Industry definition is there. In labor law, for one act, industrial dispute ID Act requires 2 classes, Workmen Compensation Act in one class we can be done. Every legislation can be completed in one class, but Industrial Dispute Act requires minimum 2 classes. And I wanted to take a public international law, and I will start a burning subject. So human rights is now burning subject. In exclusively on human rights, diploma courses are there. As in LLM level, human rights is there are so many papers on human rights. These are the various issues, dear friends. So I have completed Limitation Act in detail in these 3 classes. Whatever I covered in these 3 classes will be enough from examination point of view. And CPC, from limitation I have taken 3 classes. I took 5 classes on civil procedure code. First 2 classes are summary. First 2 classes are summary. And third class is jurisdiction of civil courts, section 10 and 11. There will be a compulsory question from section 10 and 11, sub judice and res judicata. And then I completed next place of suing. I have given one lecture, and then some one lecture, suits by indigent person is very important, order 33 rule 1. And suits by and against government, interpolated suit, and special cases of special suits. These 3 are very important from examination point of view. If time permits, I will take up next class. I wish to take up execution and arrest before judgment, attachment before judgment also are important from examination point of view. What all, even if though I do not complete 100%, even if I complete 75%, they will be more than enough from examination point of view. If the student is required to answer 5 questions, if half of the questions he has written excellently, the examiner will have very good impression. I sincerely suggest my student friends, you should not neglect summary lecture of mine. If you watch the summary lecture, you can have overall idea about the subject, and you can pick out any topic of your choice. And 10th chapter you can pick up, 15th chapter, or whatever you can. So you should have the knowledge about summary will help you. So that is the reason why I want to giving summary lecture is more difficult. It requires lot of preparation. When once a subject is started, topic wise teaching is preparation is easier. But taking more and more subjects of preparation will be. But I want to justify not less than three to 4 classes from all the subjects. This is my planning. I invite comments and suggestions from the students, in what way I have to take up the classes. I wish you all success. Thank you very much, dear friends. Thanks a lot.